I have to, what I have to do is back you up a bit. And I'm going to start where okay, let's talk about Haldeman's notes, please.
Okay. This tape was of a meeting that included the President and H.R. Haldeman, President Nixon. And the notes that Haldeman had kept of the meeting showed that Watergate was discussed. That was the subject matter of that point in the meeting where the erasures occurred. Before was something else, after was something else, but that piece of it that had been erased was Watergate. So, clearly someone had, whoever it was, and we still don't know who it was, at least I don't, had gone in, found this on it, and erased it through stopping, backing up, erasing, backing up, erasing. Looking back on it, it was quite a futile gesture. It's like taking a bucket of water out of the ocean, There's so much more there that, erasing 18 minutes isn't going to have much effect in the end. But it did affect the credibility of the White House, certainly, and anybody relating to the tapes and the hearings that were going on. And so it was difficult, but that was the conclusion of these experts.
There was some criticism. I think actually the Watergate Special Prosecution Force was a little critical of the court for not issuing a protective order for the tapes from the get-go. Mm-hmm. Was that something you had considered back when dealing with the subpoena, asking that the tapes be removed, physically removed?
No, looking back it seems odd, but there was still a great deal of trust reposed in the White House and the President and those who represented him, and it just didn't come naturally to be suspicious. It was a growing suspicion as time went on, and looking back you say we should have been more suspicious, but that was not the feeling at the time.
There was also some concern that you hadn't dealt directly with executive privilege in the August decision. Mm-hmm. You'd sort of gone around it by saying, well, we'll listen and we'll decide. But what parameters were you going to use did you get to the point where you thought, well, these are the parameters we'll use to differentiate between what is properly protected for the executive or by the executive and what isn't?
That had not been definitively decided in the judge's mind, I don't think, not in mine anyway. And the real criterion that was the focus of this, that was going to be the focus of the initial review, was relevance. Is it directly bearing on and relevant to Watergate and not other items? Can you separate it? Can you really legitimately separate this and pull it out from whatever else may be going on in that meeting or that conversation, such that it's a piece of evidence for a criminal trial or criminal investigation and does not impact the functioning of the President in legitimate matters, or the presidency in areas where he has a right to expect some privacy and open discussion in council. So relevance was kind of the base thought on how to analyze the privilege issue, but it was never really refined much more than that, because in the end it became very clear there was no national security matter. There was a very clear separation of Watergate from anything else in these conversations. It was purely a matter of evidence, and there really was no basis on which you could concoct an executive privilege to say this shouldn't be disclosed. So it turned out to be an easy decision.
I've looked at some of the filings regarding the 18.5-minute gap. It seems that both Buzzard and Garment were actually trying to blame Rose Woods for intentionally doing it. But there wasn't an indictment. She, I guess, was never tried on this.
No. I think the conclusion was, in the end, she had nothing to do with it. And, I don't know what all evidence was produced before the grand jury or what other investigation, what other evidence came out in investigation or information, but my sense of it was everybody concluded that she had nothing to do with it. There was some speculation about President Nixon himself may have done it. There was some speculation about Stephen Bull, who had custody of the tapes at that point, may have been directed to do it. I don't know who all the potential candidates could be for that, but as I say, that remains, at least in my mind, a mystery still. Who did that? In the end, it really didn't have much impact.
Well, let's talk about listening to tapes. Now you get to listen to the tapes.
Yeah.
And Judge Sirica decides that he's not going to listen to them alone.
Right. He wanted us to hear them together. So as to be able to, you want to be able to discuss it with somebody and sort out this privilege issue. And he had, that was his style. I mean, he'd always been very open, I think, with all of his clerks from day one. He didn't have them sitting out here just to do research and be his, somebody said, intellectual valet, but they were part of his team. They were almost part of the family, and at least I felt very much that way, very much included in everything. And he was an open book. He just didn't hide anything. In our conversations, his comments were totally candid. So he wanted to have that same thing happen with regard to the tapes. And it was a little embarrassing. We sit down, well, let's begin, and we realized we don't have a recorder to play them. These were reel-to-reel tapes. And we searched through the whole courthouse. The courthouse building there housed the district court, the appellate court, and the U.S. Attorney's office, and the marshal's office. Nobody had a tape recorder. They could play these reel-to-reel tapes. So we ended up making a request to the White House if they would let us borrow one of the machines they'd used to make them in the first place. So sort of going hand in hand, saying, could we use one of your little recorders? But they were very gracious. Sure, take a recorder. And the judge had that checked for bugs. He was very suspicious. And so we sit down and realize there's only one jack for a headphone. And I'll back up just a bit. There had been a lot in the press, or some in the press, about this examining the tapes in camera. That as soon as the tapes got to the judge's office, they were going to be on the street. You know, whatever was on the tapes, you know, a day later would be on the street. And the judge said, no, there is not going to be a leak out of my office. There will not be a leak out of my chamber. He was very insistent on that. And he said, this is, you know, I didn't do this for publicity, and I'm not out for publicity. I want to see justice done and protect the integrity of the courts and the reputation of the courts and the whole system. So he said, we'll listen in the jury room. This was a room with no windows. It was an interior room, so it was not even on the outer wall of the building if anybody could somehow listen in there or through a window. It was an interior room, one door, no other access, and totally private. But beyond that, he said, we won't even play it out loud. We'll listen with earphones. So he was taking every precaution possible. And we kept these tapes in a file cabinet that was really a safe. You know, it was borrowed from the National Security Administration, where it had a combination and, you know, heavy metal. And we logged everything in and out. It was a very elaborate system to be sure that it was protected. Well, the 6 experts who were examining the 18.5-minute gap were still around the building, some of them working on this, and I asked one of them, the assistant to one of these, whose name was Ernest Ashkenazi, a rabbi. He was an Orthodox rabbi, very expert in electronic matters somehow. And he was assisting one of the experts, and I said, Ernest, how are we going to do this? We got to have 2 headphones, and we only have 1 jack. And so he said, oh, I can take care of that. And he got his little toolbox, and he took the jack that goes into the recorder and spliced it the other end into 2 cylinders, and then we could plug our headphones into those 2 cylinders and the jack into the recorder. So I brought it along if you want to take a look at it on camera.
Yes. Thank you.
If I hold it here, can you see it all right?
They're going to pan down. Okay. There we go.
So this was the jack that goes into the recorder for the headphones. And up on this end, you see he had split the wires and spliced it so it would lead into 2 cylinders here. And then we would plug our headphones, one here, one there, and this into the recorder. And that way we could listen together at the same time. And you see it's a pretty, what would you say? It's not high tech.
No,
no. This is not state-of-the-art rocket science. And he put it down taped it all down with Scotch tape, and on this little piece of cardboard. And on the bottom he wrote, "Compliments of E. Ashkenazi, NYC, New York City." So this was it. This is how this is a little mechanism we used to be able to listen to the tapes together.
And how many hours of listening do you estimate you did?
Oh, it must have been 60 plus. This went on and on. It was when there were two subpoenas, as you may recall, for tapes. The initial batch of 9 were produced, and that's when this was manufactured and we used. And then as the indictments were being contemplated for a second trial, a cover-up trial in 1974, a new batch of tapes was subpoenaed by the grand jury. And in fact, that was a greater number, and we listened to most of those. The same procedure was used again, listening in camera.
Well, make it easy for you. Thanks. Tell us
Jim, do
about.
you want to ask that question one more time? He was kind of leaned forward out of his light.
Okay.
It might go better to edit to what you've been doing if you just have that.
You mean how many hours he was listening to?
Yes.
In total, roughly, estimate for us the number of hours of listening you did.
I seem to recall there were some 60 plus hours of these tapes. There were 2 batches of them. The first subpoena that we've been talking about for the 9 tapes, it turned out to be 6 and a half, I mean 7 and a half. And then when the cover-up case was being prepared in 1974, a new round of tapes were subpoenaed by Leon Jaworski, who was then the special prosecutor.
Tell us about the effect of the first round of listening. What struck you and the judge as you were listening to those first 9 tapes?
Well, we found the ones that had been recorded in the executive office building to be difficult to understand. And then the others in the Oval Office, comparatively very clear. It was almost like being in the room, listening as a participant or observer in the room at the same time. They were, as you know, voice-activated tapes. The system didn't have an on and off switch. There was a recording system in the cabinet room that had on and off switch, but this in the Oval Office, the microphones were just embedded under the lip of the desk at various points, and it was set up so that any sound would begin the tape rolling, begin recording. So everything was automatically recorded. And then the machines were down in the basement. And there was a little mechanism about as advanced technologically as this plug-in for our headphones that would switch between 2 machines at night. So, you know, one would record today, and then this little lever would flip over to the next one for the next day. And somebody was supposed to come down and take this tape that had been filled up and put a new one on. And then it would flip back, and they'd come get this tape from the second machine, and you know, alternating back and forth each day. And when some of them were not recorded, some conversations were not recorded because enough had happened in the office that day that got recorded that the tape was filled and it ran out, and they didn't go down and replace it, till that evening or the next day. So if somebody was vacuuming the carpet, the tape was running because that was noise. And anything else that created sound made the thing run. But the quality, the sound quality for the Oval Office was very good, surprisingly good. And then there was one White House phone that had a tape hooked up to that, which was, of course, very clear because that was over wire. But it was just an odd experience to sit down and be listening in on these things, to hear those voices and exactly what was going on. And the impression that came to me through all of these tapes we listened to was that President Nixon had not been aware of or involved in anything with having to do with the planning of this eavesdropping on the Democratic National Committee, or the break-in to either to put the bugs in place or to go back and try to fix them, which is when they got caught. My conviction is, after listening to all of that, is that he never knew about it, didn't have any advance knowledge about it at all. But within days after these arrests were made, he was told that it had been people from his re-election committee involved, and that money from that re-election committee had been used, and that they needed to put a cover on it if possible and not let that out. And at that point, he got involved in okaying those initial steps. There was no blueprint, no master plan for a cover-up. They sort of kind of stumbled along, step to step. This didn't work, so try something else, and trying to keep this jello, from falling out somewhere. And he got deeper and deeper without realizing it, I think, until he was in very far.
What did you think of the March 21st, 73 conversation with John Dean?
That was, it was a memorable day when we sat down to listen to that particular tape. We did not expect to hear, frankly, what we heard. John Dean came in, and much as he testified to the Senate Select Committee, kind of laid out all that had been going on. I think President Nixon, while he had approved these initial steps to try to cover things up, was out of the loop for the most part for quite a while. And when John Dean came in to say what he'd been doing, a lot of it was news to Nixon, not entirely, but a lot of it was news to him. And particularly when John Dean says the Hunt and the Cuban Americans are threatening to reveal what they know unless we can continue to provide money to them and their families. They were in jail, they expected their families to be supported. It's going to fall apart unless we can buy their silence. And then to have the President of the United States say, well, how much would it take? Instead of to blow up and say, what? People are trying to blackmail me and blackmail the President of the United States and this office, I won't hear of it. We'll never do anything like that. His reaction was entirely opposite. Well, we can get, how much will it take? $1 million. Well, we can get $1 million. The trouble is, how do you distribute it? We felt, both of us, like we'd been hit in the gut, and it was hard to breathe. It was such a disillusioning experience, because both of us had voted for Nixon twice, both times he ran, and in '68 and '72, and hoped against hope as things went on that he really wasn't a party to any of this, that it had been a conspiracy, maybe involving some of his chief aides, but not him. But this, for us, for the judge and myself, laid it arrest. I mean, there was no doubt after that. And it was a terribly disappointing and disillusioning moment to hear that. In fact, he passed me a note. We wouldn't talk to each other because we had our earphones on, but he wrote this note. He said, "Shouldn't we hear this again?" It's like, do we really hear what we thought we heard? So we rewound it and played it again. And, you know, as I recall, when that was over, we just said, you know, packed up the tape, put it back in the safe, and went home. We just didn't have the stomach to do anything more that day.
Did you think the president would be impeached?
I think so. You know, after that, we thought that was very possible. You know, even then, though, it still seemed like a bit of a far-fetched idea. But having heard that, at least my conclusion was that really is now a realistic possibility. Before that, I didn't think so.
You did before listening to it.
Right.
Tell us how it affected your opinion of John Dean.
Well, it's hard to know. Obviously it enhanced his credibility in the sense that it was obvious he had told the truth, and his excellent memory was an excellent memory. It wasn't something else manufactured. I was impressed with that, and with the fact that he finally did come forward and get out of the mess, put an end to it. But he obviously had done a lot and spent a lot of time in criminal conduct, in obstruction of justice, and I don't know how you justify that. But as a personality, he's a very, very pleasant person to be around. He's a very interesting person to be around. I mean, you'd love to spend time with him. But he just did some very bad things. His judgment was extremely poor in doing what he was ordered to do instead of saying, no, I won't go there. But I don't know. It's hard to judge him because, you know, when you're in that position, you're in the White House, you're the counsel to the President of the United States, you're in that rarefied air, and you're trying to protect your boss. You know, you ask yourself, would I say no when I should say no? I hope so, but I can understand, you know, why he succumbed to the temptation, if you will.
Just to backtrack a bit, did he not provide materials to Judge Sirica? Did he not give you a passel of documents to put in?
He did. That he had in a safe deposit box in a bank in Virginia. And Rich Azaro and I went out and picked it up, brought it back. It was something called the Houston Plan, H-U-S-T-O-N. And I'm trying to remember now, it really didn't have anything to do with Watergate. It was something to do with kind of thing the plumbers did, you know, finding out who's leaking and going after them and preventing leaks from the White House, as I recall. It's kind of vague in my mind now, but it was played up to be some great thing bearing on Watergate, but it wasn't related to that.
But did he explain to you why he had these documents?
He never did directly that I recall. I got the impression that he was using it as kind of an ace in the hole, you know, if you want to come against me, I've got this that I can reveal about you, and therefore you better treat me right. But that's my guess.
I understand the court considered perhaps appointing a special prosecutor. During that period when the Special Prosecutor's Office was abolished by, I guess it was the Solicitor General, Robert Bork, the court considered choosing its own special prosecutor, didn't it, briefly?
Yeah, that was brought up as a possibility. It was urged on the judge by by some in Congress, as I recall, the Senate or the House. But we looked into it. There wasn't any, as I recall, any real clear precedent one way or the other. It seemed like it was possible, that could have been done, but he was very reluctant to go there unless there were no alternatives, and in the end, it wasn't necessary.
Please compare and contrast Jaworski and Cox for us.
Well, Jaworski was a very able practicing attorney. He's somebody who was in the profession, in the action, if you will, of trial work, prosecution, and other kind of trial work, and was just very good craftsman, if you will, and represented, I think, some of the finest aspects of practicing law. Archibald Cox was more the academic, the philosopher, lawyer, and obviously had experience himself as well in some practice, but his real strength was in his erudite mind and analysis and ability to analyze and express. He was just superb in his powers of expression. So they had different strengths, but both very good.
We're going to have a
4
second.
minutes left. Take 4 minutes.
Thank you. We're going to have a second round of subpoenas. March of '74, you have a second round of subpoenas. How was the judge managing 2 grand juries? Was this going to be an extension to the break-in trial, or was it going to be a new trial with these new indictments? Had you sort of ended that first trial and now you were on to the second?
That's true. Yeah, really the break-in trial was a thing resolved at that point, and the cover-up became quite a separate issue. The obstruction of justice, very different from the actual break-in. And the new tapes subpoenas were related specifically to that, not to the planning of the break-in, but to the cover-up of what came afterward and who was responsible. So they were separable. The prosecutor's office, the special prosecutor's office, was managing the grand juries. The judge really didn't have much to do anymore day to day with them, as had been the case early on with the first grand jury. His involvement really came in that interim period, the interregnum, when their function and their existence and their supervision was in doubt.
When one looks at how this case was investigated, you have a lot of focus, you have focus on the burglars,
Mm-hmm.
and there's a focus on the cover-up, but there never really was an investigation of how the break-ins were ordered. There's still enormous sort of doubt as to how they were ordered. What was your theory from watching it, from having watched the break-in trial and then seeing the indictments for the cover-up case? Did you and the judge come up with a theory of how this was ordered in the first place?
Yes. As best I could piece it together anyway, it appears that the original idea for the eavesdropping in the Democratic National Committee's offices and other things that didn't happen, that were planned, came out of Gordon Liddy's head. These were his idea. He codenamed it Gemstone. It was the Gemstone Project. And it was a grand scheme. I mean, he had some kidnappings involved where he would take people out of commission, so to speak, for a period of time when they were supposed to be doing something important in the campaign, like giving a speech at the convention or whatever. And intercepting mail, this eavesdropping, it was pretty elaborate. And he brought it forward. He was working for the committee to re-elect the president and brought it forward to get funding and permission. And I don't know all the details, but somehow he ended up in the office of John Mitchell, then Attorney General of the United States, but preparing to move to take over the campaign for the re-election, and with John Dean at the time, and proposed this. And I'll never understand why he wasn't summarily fired and dismissed and thrown out. And maybe John Mitchell was trying to let him down easy or something, but he just said, oh, it's too expensive. It was $1 million price tag. If he was trying to give Liddy a hint, he didn't take the hint, because he came back with a $500,000 version, you know, cutting back on some of the activities, and that was no, and he came back finally at a meeting in Florida, again with Mitchell, for a $250,000